All right, Mr. Garcia Jr., if you'll come down. Court is calling 2023 CR 6937 State versus Oscar Adame Garcia Jr. Can I have parties announced for the record for the state? And are you Mr. Garcia? All right. Did you review the document entitled Motion to Revoke Community Supervision and First Amended Motion to Revoke Community Supervision with your attorney? Did you understand it? Are you the same Oscar Adame Garcia Jr. who's placed on community supervision in 2023 CR 6937 for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on August 24, 2023 for a term of 18 months? Is that you? All right. Did you understand by pleading true to violations 39 and 40, the court could find it true, grant the motion, and sentence you up to 1 year in the state jail facility? And there's no fine. Did you understand I could sentence you up to 1 year in the state jail facility? On the plea bargain agreement, they have this underlying sentence as 1 year. So no, this, I don't understand this writing. I think it says 1 year probated for 18 months. Oh, sir, you can have a seat. All right, y'all ready to? All right, if you come back, please. All right, we're back on the record in Oscar Adame Garcia Jr. in 2023 CR 6937. Did you understand by pleading true to violations 39 and 40, the court could find it true, grant the motion, and sentence you up to 1 year in the state jail facility? Knowing that, do you still wish to plead true to violations 39 and 40? Court will find violations of 39 and 40 true. All right. Are you asking the court to follow that agreement? Are you waiving your right to appeal? All right. The court will grant the motion. The court will revoke, sentence you to 15 months in the state jail facility, give you credit for any time served, take in consideration 2024 PF 21201, and I'll request the therapeutic community. Is there anything else with regards to sentencing? All right. The question for whether or not the court would consider giving that to him is going to be, did he successfully complete it or not? And I'll need some documentation for that. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. All right, Mr. Garcia, I requested the therapeutic community for you. It does not increase the time that you serve, but it can perhaps help you with any drug or alcohol issues you may have. I can't force them to place you in the program, but your sentence is for the 15 months. So for example, if you've done your 15 months and you're ready to be released, they're not allowed to say, oh, you haven't completed the therapeutic community, so we're going to keep you. If they decide to release you in 13 months, the therapeutic community is not going to hold you up from your release, but it's just there to help rehabilitate you. You understand? All right. Good luck to you. Okay. You're welcome. Thank you. All right. James McGarity. All right. Where are we on this case?
Judge, there is a video that I have talked to the prosecutor about that I do not have in my possession. She's working on getting that for me. We tried to do it today on a flash drive. It was not working, so she's going to put it on a disc for me and get it to me this week.
So you do have the video in your possession?
Yes, Judge, and it's on the e-discovery system. It's marked as discoverable, so I'm not sure what the issue is there, but Steel Ginkgo did provide me with an external drive, and for some reason it just wasn't compatible to upload on there. And so it is in my possession. I plan to turn it over this week.
And I'll look on e-discovery again, but I know we went through all the discovery and I don't have it at this point. So.
All right, Norma, if you'll set this for January 27th and states you'll need to be prepared to tender an offer at that time.
Yes, Judge.
All right, is there anything else?
No, Judge.
All right, once you sign the reset form, you're excused.
Thank you, Judge.
Thank you. You're welcome. Casanova, Richard Casanova?
Yes, Your Honor.
All right, so on this case, let me see. The jury found him guilty and he's coming to the court for punishment.
Yes, Your Honor. Applied for probation.
All right, thank you. All right, court is calling 2024 CR 0073660-2, State versus Richard Casanova. Can I have parties announced for the record for the state? Defense?
Michael Collins, attorney for defendant, present and ready, Your Honor.
And are you Mr. Casanova? All right, he was found guilty on December 4th
Yes, Your Honor.
by the jury. And he elected to have the court assess punishment. The PSI was waived by defense in the state. Is that correct?
Yes, Your Honor. I did.
Any defensive, yes, I have no objection to moving forward now.
Okay. And so we set it for this time for anyone to present any evidence or if they had any witnesses.
We have no witnesses other than my client, Your Honor.
The state criminal witnesses, Judge, we are going to admit,
Moving to amendment 67 1 and 2 for the sentencing.
No objection.
We are also gonna ask the court to consider all the evidence that was admitted in the evidence defense.
All right, states exhibits 1 and 2 are admitted without objection and they appear to be judgments. Any other evidence, state?
no.
All right, defense, any evidence?
Just argument, Your Honor.
All right, did you want to call your witness or no?
Let me ask him if he wants to speak, Your Honor.
Okay, sure.
Yes, upon, yes.
Yes, Your Honor. I would call my client.
All right, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Richard Thomas Casanova.
All right, do you want to ask questions or is there something
think he wants-
specifically he wished to say?
Richard, do you want to address the court at this point about the punishment phase?
I just want to say that when I get out, I'm not gonna go back to my mom's house or my daughter's, and I'll go to Haven Furtlow. And I wasn't aware that I couldn't go, to try to get my mail. I thought that the protective order had expired because it was 1 year and I could never get my mail, so I didn't know what was going on. I was put on the street pretty much. I didn't have no place to go. So.
All right, any questions? All right, so what I can tell you, Mr. Casanova, the fact that you're telling me that you didn't know about the protective order, that is what's considered as mitigation evidence. These type of offenses are sort of like strict liability. It's, was there a protective order in place? That's either yes or no. And did you violate it? Yes or no. So that's the way these type of charges are. There are some charges that are slightly different, but not this. Okay?
Yes.
All right. State, what are you requesting for punishment?
Given the history judge and practice of the first where we asked for years to see.
All right, and defense, what are you requesting?
Could be requesting probation in light of he's been incarcerated since the date of the offense, which was late April of 2024, Your Honor, hasn't been in trouble with jail. And he is expressing to the court that he has no intention of going back there, Your Honor. He was under what he thought was a mistaken belief of fact, Your Honor.
I do have one thing to add. He was indicted as a repeater. We're just gonna ask for the judge my intention.
All right, so let me see the indictment. And you're proceeding on the repeater enhancement allegation?
Yes.
All right, Mr. Casanova, you're still under oath. I'm going to read the repeat offender enhancement allegation paragraph, and I need to know from you if it's true or not true. And before you answer, you can discuss that with your attorney. It states, and it is further presented in and to said court that before the commission of the offense alleged above on the 24th day of June AD 2010 and cause number 2007 CR 2886 in Bexar County, Texas, the defendant was convicted of the felony of criminally negligent homicide with deadly weapon. So the question is, how do you plead to that, true or not true? And you can speak with your attorney before answering.
True.
Right. Then the court will find that true based upon your plea of true and based upon state's exhibit number 1. Now, what the court's understanding is that this location he went to, is that the daughter's house, mom's house, his house? It appears that during the testimony, he was saying that's his actual place of residence. I know sometimes when there are violations of protective orders that are filed, whoever they deem to be the offending party, they make them leave, whether their name is on the property or not. So the persons who were at the home, what I remember from the testimony is it was his daughter. Is that correct?
Correct, Your Honor.
Yes, Judge.
So is this protective order involving the daughter, that location, and his mom?
Daughter. Don't have to check to see if there's any other parties that are protected, but I believe it's.
That's the only one that was unprotected.
So here's my question.
Daughter and the rest, and that address.
Yeah.
So here's my question. Has anyone spoken to the daughter?
So I can inform the court of what the daughter told me, but of course I don't know how.
Well, do you want to speak to the attorney before?
Let me
Yes.
just go like, give me like 30 seconds.
Sure.
On the record, so I did speak with the complainant one time after one of our investigators went over to the address to make sure that somebody was present. We have called her multiple times, texted her, she had not returned her calls until one of our investigators went to the location and found her. She called me, I spoke with her. I did explain to her about the case, about being in trial and her coming over to present her testimony, and she did indicate to me that she did want to testify. However, she could not make any arrangements because she is the caregiver of her grandparents,
Mhm.
and she could not make coming to court for that. We did make efforts to reach out to her over the phone. We confirmed that that was the correct number that we had. And after the guilt innocence, we did try to inform her about her coming over to testify during the sentencing, but she has not returned our calls. I have not sent out an investigator to her location again.
All right. So part of the consideration the court takes into consideration, or evidence that the court takes in consideration, especially in this case, one, of course, is protecting the community, and two, protecting the parties of the protective order. Now, sometimes family relationships between fathers and daughters, fathers and sons, mothers between their children as well, it's difficult. So what I would like to know, if it's possible, if it's not possible, I'll make my ruling without this information. But if you all want to just try again today, state you and the defense counsel to reach out to the complainant, find out if she has any fear of him, and what her thoughts are on sentencing. And then I'll make my ruling, but I'll make my ruling today.
As long as I can be present on the conversation.
Yes.
If we aren't able to get a hold of her today, I just want to make sure with defense, if you have any objections, we can bring it over Zoom.
No,
Okay. All right, let's try to do that. I want to make the right decision on punishment, okay?
the caveat, I'd like to be able to handle it sometime today because I start vacation.
No, we're starting it today.
I just.
So it's gonna happen
Okay.
today. If she
I was gonna-
appears, she appears. If she doesn't appear, she doesn't appear.
Can we have 5-10 minutes?
Sure. This is just information I would like to have.
It's fine.
Jenna Rodriguez?
We're here, Judge, we're ready.
All right, do you know on this case, where is Jenna Rodriguez?
She's right here, Judge.
All right,
She's coming forward.
all right. On this case, do you know if the evaluation report, do you have that or not have that?
Yes, we've already done that, Judge.
And has it already,
We've accepted the results of the evaluation.
all right, and what were the results?
She was competent.
Okay. State, were you able to tender an offer?
Yes, Your Honor.
All right, Norma, if you can set this to the week of January 6th for plea deadline date. All right, January 7th. At that time, you'll need to let the court know whether you're accepting the state's offer. You understand?
Yes.
All right, thank you for dressing appropriately for court. Once you sign the reset form, you'll be excused. You're welcome. Johnny Joe Aguirre. All right. Does he only have the one case?
Yes, ma'am. He had an MTR, and this one, Ms. Megan Cook represented him. He was sentenced, I think, 6 years last time we were here, so we're here on a discovery, is my understanding.
Yes. So where are we on discovery?
I think we have everything, Judge.
All right, state, were you able to tender an offer?
They have, Judge, they have tendered me a couple different offers.
Okay. All right, then I'll put it for a plea deadline date.
Okay.
Are you available the week of January 6th?
I think I'm gonna be out that week, Judge.
Okay.
Until the 13th I think that's a Monday, if I'm not mistaken. I will be gone until then,
Okay.
so I can't do
All
the
right.
13th.
Ms. Ferguson, can you put this the week of the 20th, please? And of course, the 20th is a holiday, so anything after that.
Sure.
All right, 23rd.
All right. Thank you, Judge.
All right, thank you. All right, we'll bring you back on the 23rd. At that time, you'll need to let the court know whether or not you're accepting the state's offer.
Okay, thank you.
All right, you're welcome.
I have excuse, Judge.
Yes. The last case I'm gonna take up is gonna be Studemire, your case, sir, and Bridget Garza. I'm gonna take your case up. Okay. And then the other people will have to come back for the afternoon. And the other exception to that is the attorney for the sentencing.
Well, our case will excuse.
No, I'm gonna take it up. I'm gonna give you your answer. Unless you're able to, are you able to come back this afternoon, counsel?
Not really.
Well, then why ask? That's my thing. I don't understand what's happening today.
Well, if you're gonna make a ruling.
I'm gonna make a ruling. Thank you, counsel. Counsel, if you would like to zoom in for the ruling, you can.
Say,
I said, if it would help you out, if you would like to rule in for the zooming, you can. Zoom in, if you would like to zoom in. Okay. Could
I'm not
somebody
sure I
explain-
understand you.
All right, can somebody explain that?
Get on Zoom this afternoon.
Zoom, oh, you're saying Zoom. I didn't understand what you were saying.
Was I not saying that correctly?
Did say rule in to zoom in.
I'm like, all right, so yes, if you would like to appear by Zoom for the afternoon, you can. So would you rather appear by Zoom this afternoon, and I will give you my ruling?
Are you capable of doing it now?
I am busy right now.
Then we'll do it this
All
afternoon.
right, thank you.
Speaking of Zoom, Judge, I've got Joseph Smith online. If you want us to come back at one.
No, he's not on,
Yeah,
he's not here, but if you could come back at 1:30, that would be appreciated.
He didn't log on.
No. Zoom. It's been a crazy day today.
All right,
People are
figure
sick.
that out.
Yes,
Judge, will you be available to be approached off docket at the 1:30 docket?
yes.
Awesome, thank you.
All right, thank you.
What time is the Zoom?
She called up.
The Zoom, what time is it? 1:30?
And then I don't know why this equipment is not working either. This is off, so I can't even. Can you reboot that, please? Somebody, I think, touched that.
The judge calls my client here, Kirchmer, while I was in the hall.
Yes,
Kirchmer, yeah.
yes.
Can we approach on that? Which,
Yes.
some.
So you're saying you put in all the documents?
We put in all the documents, Your Honor, signed the contract, turned it in. And I put an email this morning.
All right, can I get a PTD date on Kirchmer, please? All right, January 13th. Once you sign the reset form, you're excused. Thank you.
Thank you, Your Honor. Appreciate it.
You're welcome. All right, we're back on the record with Mr. Casanova. All right, we're back on the record and 2024 CR 007-360-02 State versus Richard Casanova. All right, State, did you have a chance to reach the complainant?
We have Judge Diaz, we have not successfully reached the complainant, our victim advocate did come down earlier, and while defense was present, she did make 2 phone calls to the number that we have for the complainant. There was no answer, she did leave a voicemail, informing the complainant to call us back for the next 5 to 10 minutes. As the court asked some questions, we did offer hearing over Zoom as a possibility, as an option, in the voicemail. She also sent a text message, but that was more than 10 minutes ago at this point, so we have not been able to.
All right, so and are both parties still wishing to proceed without the input from the complainant, State?
At this point, Judge, it's pretty clear that the complainant does not have any part of the session.
All right, defense?
We proceed without.
All right. So what I can tell you, Mr. Casanova, I don't think that probation will be appropriate in this case. I have to consider your entire history. It's not just this one incident. All right. So then the question becomes, the state is requesting 8 years. What are you requesting?
I request a minimum, Your Honor, 2.
Okay. All right. This is what the court is doing. The court is finding the enhancement true based upon your plea of true and based upon state's exhibits 1 and attachments. The court has heard all the evidence in this case. Based upon the evidence that the court heard, I understand the nature of protective orders, but it doesn't appear that from the testimony that the court heard that the defendant was there to be violent, that the defendant was there to cause a disruption. The only testimony that the court heard was that he was there to collect his mail. And the testimony that he gave sounded believable to the court and sounded credible. Because otherwise, why would he just be waiting, if not to pick up his mail, as he said? But we're not allowed to be at the residence. You understand? All right, the court is going to sentence you to 3 years in the prison, give you credit for any time served. Let's see. All right, I don't have your trial court certification in here. You may have filled it out,
I did.
but it is not here. So do you mind filling out another one? For the
Yes.
court? And then I'm also, as a part of your sentencing, I'm going to order no contact with, let me see. I don't have the state's exhibits here. Who is the,
We're still with a C, Casanova.
there's to be no contact with Crystal Casanova. Do you understand?
Yes, Your Honor.
That's from here till eternity. Now, if she decides that she wants to see you, then you all will need to file motions with the court and ask that that be removed. Do you understand?
Yes, Your Honor.
So any location where she may be, you're not allowed to go there. Do you understand?
Yes, I do.
Whether it's your house or not your house. If it is your house and you feel as though you have a right to be there, that's something that needs to be settled in the court of law. That's not something where you just show up.
Yes.
You can't show up for your mail. You'll need to go to the post office and ask them to change your mailing address. Do you understand?
Yes, Your Honor.
All right.
Sure.
All right. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
I understand.
All right.
That's-
This is a jury trial, so you do have a right to appeal. We can go off the record. If you wish to appeal, your attorney will know to file the notice. And if you cannot afford appellate counsel, one will be appointed to represent you.
Okay,
All right. Good luck to you, sir.
thank you, Your Honor.
You're welcome. Counsel,
Okay.
you're welcome.
Any excuse, Your Honor?
Yes, you may be excused.
Grab some lunch downstairs, Judge.
I'm sorry, what?
Can I grab some lunch downstairs?
Sure.
Is there,
Yeah.
Will you not be accepting a verdict until a certain point, or
No,
if they
that's
called you?
whenever they call, they
So I'm
call.
just in the cafeteria.
All right, sure. They'll send you a text message. Cindy, it's almost like it was a full moon, and it's still a full moon now. All right, Rudy Gonzalez. And there, and probation, you can be excused. There are no applications on this case. You're welcome.
1:30.
Well, 1:30-ish. Ish, yes.
Mr. Gonzalez is just restored, Judge.
All right. Good afternoon, or, yeah, good afternoon.
Good afternoon.
How are you feeling today? It's not a true question, I
It's
promise.
a lot better,
Oh,
I
that
gotta
is good.
say.
Yeah. All right.
All right. All right. Court is calling 2024 CR 4541 and 2024 4494 State versus Rudy Gonzalez. Can I have parties announced for the record for the state? Defense.
Bridget Garza.
And are you Mr. Gonzalez?
Yes, ma'am.
Counsel, in each of the cause numbers, have you received all discovery and reviewed that with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. And each cause number, Mr. Gonzalez, did you review the true bill of indictment with your attorney? And did you understand it?
Yes, Your Honor.
Counsel, in each cause number, do you waive the reading of the indictment?
Yes, Your Honor.
State, in the cause number ending in 41, are you proceeding on the indictment as presented?
You are, Your Honor.
And in the cause number ending in 94, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving count one and the enhancement paragraphs and just proceeding on count one. Can I say count one, then the first one?
Yes.
Waiving count two.
Okay.
I just realized that step right there. And proceeding on count one. And that's the third degree theft, 30,000 to 150,000 vehicle, Your Honor.
All right, any objection?
No objections, Your Honor.
All right, and the cause number ending in 41, you're charged with burglary of habitation, and the cause number ending in 94, you're charged with theft, 30,000 to 150,000. Those documents that have those charges in it, it has in there your rights and certain things that you're giving up by entering the plea bargain agreement in each of these cause numbers. Did you review those documents with your attorney? Did you understand them? And did you sign them in all the appropriate places? All right. And the cause number ending in 41, the range of punishment is 2 to 20 years. And the cause number ending in 94, the range of punishment is 2 to 10 years. If you have a plea, I don't have to follow that plea. If I don't follow your plea and give you more than you bargained for, you can withdraw your plea. And this can be set for trial. Do you understand? Do you understand in each of these cause numbers, you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand by entering these plea bargain agreements, you were giving up those rights? And did you intend to give up your rights and enter into a plea in each of these cause numbers? Did you intend to give up your rights and enter into a plea bargain agreement?
Yes.
All right. Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does now, Your Honor. Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
And it's the court's understanding that competency was restored?
Yes, Your Honor.
Mr. Gonzalez, has anyone threatened you to get you to enter a plea in these cases? Anyone coerced you or forced you to enter into these pleas? All right. Anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented?
I'm satisfied. Yes, ma'am.
All right. Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In the cause number ending in 41, according to the agreement, punishment is to be assessed at 8 years. There's a $2,000 fine. This will run concurrent with the cause number ending in 94. There's going to be restitution to Venkata, Venkati, Leccareddy, Lakkiredy of $500. The state will take in consideration 2024 CR 4493 4066 and 2023 CR 7253. And the cause number ending in 94. According to the plea bargaining agreement, punishment is to be assessed at 8 years in the prison. And this is running concurrent with the cause number ending in 41. And there are no applications in either of the plea bargain agreements. Did you understand that to be your plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your Honor.
And each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yeah.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
All right, then in cause number 2024 CR 4494 to count 1, how do you plea? Guilty, not guilty, or no contest?
Guilty, Your Honor.
And then in cause number 2024 CR 4541, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State any evidence.
Your Honor, in each of the cases, state exhibit number 1 is attached.
Any objections?
No objections, Your Honor.
And each cause number, did you review a document? And that document is the stipulations. It has the police reports in it. It has witnesses' statements. Basically, the evidence that the state is submitting to prove you guilty beyond a reasonable doubt. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
All right. You do understand that you do have a right to a jury trial. Do you understand that? All right, so that would mean that witnesses would come in, the state would call witnesses, and those witnesses would testify, and your attorney would get a chance to ask them questions, and nobody could force you to testify. Did you understand? So today, the state is just going to present those witnesses by presenting statements that they've given to the police and police reports. Did you understand?
Yes, Your Honor.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, in each cause numbers, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. I've been representing Mr. Gonzalez for over a year. And now that he's been able to get some treatment for his mental illness, he's had a clear head. He's pleading guilty because he is guilty. He is remorseful. He takes responsibility. And he wants the court to follow the recommendation of the ADA. He does have a drug problem. He recognizes that, and he understands that when he's in prison, he's gonna have time to reflect on the poor choices that he makes. He's gonna try very hard when he gets out to try to stay off the drugs that caused him to be before the court. And so he's asking the court to follow the recommendation of the ADA.
All right. All right, and the cause number ending in 41, the court will find you guilty, sentence you to 8 years in the prison, give you credit for any time served. There's a $2,000 fine, time and money to run concurrent. This will run concurrent with 2024 CR 4494, taking consideration 2024 CR 4493. 4066 and 2023 CR 7253. There's to be restitution in no contact with Venkata McGarity, and the restitution amount is $500. And I'll order the therapeutic community. The therapeutic community doesn't increase the time that you're in custody, but it may be able to help you with any issues you may have. Do you understand?
Thank you. Yes, ma'am.
You're welcome. I can't force you to be in the program, and I can't force them to put you in the program, but they'll see on the judgment that I'm requesting it. You'll still have to ask for it. You're welcome. And the cause number ending in 24. The court will follow your agreement. The court will find you guilty as previously stated, sentence you to 8 years in the prison, give you credit for any time served. This will run concurrent with 2024 CR 4541, and I'll ask for the therapeutic community. Is there anything else with regards to sentencing in each of the cause numbers, state or defense?
No, Your Honor.
All right, in each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorneys? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. Make sure that you ask for the therapeutic community. It's there to help you. Like I said, it's not going to increase the time that you're in custody. If they are planning on releasing you in 2 years, they're not going to say, oh, he hasn't finished therapeutic community, let's not release him. That's not the way it works. And when you're released, if I'm still here and you can't find a place to stay, or you can't find, Center for Healthcare Services, just come in and I'll pick up the phone and call somebody, okay?
Yeah.
You can't stay with me, but I'll find a place for you, okay?
Um,
All right, good luck to you, okay? You're welcome. Have a good day.
Rudy Gonzalez Jr., age 32. 29 cases, 22 arrests. 2023 burglary of habitation. Sentenced today to 8 years concurrent, Texas Department of Criminal Justice with jail credit 353 days. 2023 POS CSPG 1 is equal to 1 gram to 4 grams. Today dismissed, defendant convicted other. 2023 theft prop equals $30,000 to $150,000 being sentenced today. 2023 unauthorized use of vehicle being waived today. Sentenced today to 8 years concurrent, Texas Department of Criminal Justice with jail credit 353 days. 2023 credit card or debit card abuse today dismissed, defendant convicted other. 2023 burglary of vehicles, dismissed November 2024 dismissed, other. 2023 unauthorized use of vehicle today dismissed, defendant convicted other. 2023 evade arrest or detention 2 NDOR reject, multi-count. 2023 criminal trespass private prop sentence 22 days. 2023 credit card or debit card abuse today dismissed, defendant convicted other. 2023 burglary of vehicles, dismissed November 2024 dismissed, other. 2023 unauthorized use of vehicle today dismissed, defendant convicted other. 2023 evade arrest or detention 2 NDOR reject, multi-count. 2022 robbery dismissed, missing witness. 2022 theft under $100 enhanced sentence 9 days. 2021 threat of family household sentence 78 days. 2021 assault bodily injury married but dismissed, defendant convicted other. 2021 unauthorized use VEH dismissed, defendant convicted other. 2017 robbery sentence 3 years TDCJ, def released TDCJ, the 25th of January, 2021. 2013 AGG ASSLT against pub serve sentence 7 years, def release TDCJ, the 25th of January, 2021. 2013 POS CSPG 1 less than 1 gram dismissed, defendant convicted other. 2012 resist AR search transportation dismissed, defendant convicted other. 2012 evading arrest or detention WVE dismissed, defendant convicted other. 2012 felon POS firearm sentence 2 years TDCJ. 2012 DWI WBAC 0.15 or higher sentenced 5 months, 87 days. 2012 unlaw carry WPN dismissed, other. 2011 POS Marriage 0 to 2 ounces dismissed, guilty different charge. 2011 theft $50 to $500 sentenced 1 year probation, revoked, re-sentenced 5 months, 87 days. 2010 evade arrest or detention sentenced 45 days. 2010 graffiti $500 to $1,500 sentenced 60 days concurrent, served 28 days. 2010 graffiti under $500 sentenced 60 days, served 28 days, concurrent. 2009 graffiti church, school, COM-CT sentenced 3 years deferred, revoke sentence 6 months, 289 days credit. 2010 AGG SMEXUAL assault dismissed, other. 2009 theft $50 to $500 charge entered in error, yet he was in jail for it.